Today, President Trump will be in attendance at the Supreme Court to hear arguments on his attempt to upend birthright citizenship. It's something no sitting president has done before. And there is, of course, a lot at stake here. The case itself considered legally weak. President Trump is risking a major political defeat at a time when his poll numbers as well are sinking.
All of this legislation, all of this, everything having to do with birthright citizenship, it was at the end of the Civil War. The reason was it had to do with the babies of slaves and the protection of the babies of slaves. It didn't have to do with the protection of multi-millionaires and billionaires wanting to have their children get an American citizenship. It is the craziest thing I've ever seen.
Shan Wu, defense attorney and former federal prosecutor, is joining the group chat. I'm going to pepper you with the first few questions, my friend. When we look at this, just first of all, take us inside that room. So when these arguments are happening in the Supreme Court, the fact that the president will be there, what does that change in a room?
I actually don't think it's going to change much in the room. Okay. I mean, the optics politically and to the American public are big. But inside that room, in fact, if anything, the justices are going to lean over backwards to make sure there's not even any effect of that. I don't think that the advocates are going to say anything about that either.
So when we look at what we will likely hear today in court, John Eastman, Trump ally, of course, who tried to devise the plan to help overturn the election in 2020, is the driving force behind this. This is part of what he has said about birthright citizenship.
The 14th Amendment says you got to be born here. That's requirement one, but you got to be subject to the jurisdiction here as well and reside in a state. That means temporary visitors, and certainly those who are here illegally, are not covered by the automatic citizenship of the Citizenship Clause. And that was the way we understood it for about a century. And it kind of gradually, beginning in the 1950s or 60s, we moved away from that position.
How sound is that argument?
Pretty unsound. If you were to take his argument, for example, you could extrapolate that children of Confederate soldiers should not be citizens because they were not under the jurisdiction of the U.S. They're challenging that. So it really doesn't make much sense at all what he's saying. The plain meaning of the words are quite obvious. The very creation of the 14th Amendment was meant to combat racism. And really, implicitly, people who are challenging that clause are really espousing a racist viewpoint. It's very hard to get around that no matter what sort of legal arguments you want to couch. Just because you have a legal argument doesn't mean it's not racist.
Fair point. I was also struck by, in a preliminary stay hearing, comments from Justice Sotomayor. So she said the administration's theory makes no sense, in her view, in a modern globalized context, noting it would lead to, quote, administrative chaos in every hospital in America. How important is the potential burden on, whether it's hospitals or states or whatever it may be, records offices? How much does that come into play? How much do you expect we would hear about that in arguments?
I think we'll hear a lot about that in arguments. I think you're going to hear even the conservative justices will be very concerned. How would you implement this? You're creating a class of perhaps stateless children. Clearly couldn't be retroactive. That would be like completely out of control. But going forward, potentially you're affecting millions of babies and children. And I think they'll really zero in on to the administration. Well, nice theory, but how will this actually work?